Am I audible?
Yes, ma'am.
Okay. Hello, my name is Sukanya Subramanian. We thank Legal Vidya for providing us with such a wonderful opportunity. Without further delay, we will just start with our presentation. Miss, would you please present the PPT? So hi. So we are SR Clat Notes. So SR Clat Notes, we started with an aim to provide specially curated notes for Clat PG exam. Both of the founders, we have experience in cracking Clat PG exam. I have secured rank of 347 in the year 2022, in the year 2019, and 247 in the year 2022, while Miss Rintu Mariam Biju has secured a rank of 1056 in Clat 2023. So this is a very new venture that we are starting, and by this, because we have experience in writing CLAT and experience in cracking CLAT, so we have prepared the material in such a way that it will, help people to crack this exam, and the materials are prepared that it is in line with the syllabus that's usually seen in the CLAT exam. Now, I would like to introduce the courses that we provide. So currently, we are providing two courses. First is rapid revision plan. So in rapid revision plan, we are giving a case summaries of 100 Supreme Court judgments from the year 2016 to 2023. This is done especially because in the recent years we are seeing the consortium, they are actually asking landmark judgments starting from the year 2016. So that's why we are covering from the years 2016 to 2023, and these are all important Supreme Court judgments. And these also include several constitutional bench judgments as well. And secondly, under the rapid revision plan, we are also providing a special module for constitutional law and contract law. And the original price is 3,640 rupees, but now at the discounted price, it's available at rupees 2,000. The second plan is the smart revision plan. So in smart revision plan, this is for someone who does not require module on constitutional law or contract law, but they just require the case laws that in for the years 2016 to 2023. So this only contains 100 Supreme Court case summaries, and the original price was rupees 3,150, and now we are providing at a discounted price of rupees 1,300. I will be inserting the link to our store in the comment box itself so that you can check it out. Then thirdly, we are also providing optional modules. So someone who does not have notes in constitutional law, but you want to cover, it's such a wide topic, so you want to cover constitutional law. So we are providing optional module. So optional module is available at price rupees 750 rupees, and we are covering all the important topics that's usually asked in CLAT PG examination. This includes static, mainly it's static notes. Okay. So let's begin with the first session. That's how to crack the CLAT PG exam 2024. So we have collected data over the time, and we went through all the question papers. And these are the data we collected for years 2021, 2022, and 2023. So this chart here shows itself like how important each subject is. So here you can see law of constitution is what has remained constantly the most important subject for CLAT PG exam. Then secondly, what we are seeing is recent trend is that many NLUs, when they're conducting the exam, they're also focusing a lot on corporate laws. This wasn't the case at beginning. In beginning, it was mainly just constitutional law and then more on jurisprudence, like traditional schools. But now they're actually focusing a lot on contract law, on corporate law. So that's why you can see a shift from the years from 2021 to 2023. There is a current shift that you can observe. Um, then now we have also set a expected pattern that you can expect in the year 2024. That's this exam. So if you can see for 2022, 2021 and 2023, law of constitution has been constantly, they have been given at least 30 questions. So you can expect at least 30 questions from the topic of law of constitution. Secondly, what happened 2021, 2022, they were giving importance to family law because you can see 12 questions coming from family law. But in the year 2023, they did not ask any question from family law. So we believe that in this year definitely there might be questions coming from family law for sure. So we have placed that in the important 6 to 12 questions coming from family law. Thirdly, for criminal law, there has been the trend is not that consistent, but still you can at least expect a minimum of 18 questions coming from criminal law, because criminal law includes your IPC, Evidence Act, and CrPC. And for CrPC also, the main important topics has always been bail and section 482, inherent powers of the High Court, and evidence also. There's electronic evidence, then there is dying declaration. So all this new topic that's coming under criminal law. So they're also focusing nowadays on criminal law. Then fourthly is law of contracts. Law of contracts has remained a stable. You can expect at least one paragraph or two paragraphs. But the thing is, like, law of contracts is a very basic subject that everyone should have some understanding about law of contracts. So they are basically, these questions are based on your fundamental concepts regarding contracts law. Then there is international law. International law has always been a part of Clat syllabus. It's a mandatory subject that will come for Clat syllabus. So for international law, what the exam authority is doing is they will mix international law with human rights or environment law with other fields of law. So you can expect a mix of international law principles as well as environment law principles. Now, another important topic is corporate law. So, if you see in the year 2021, there was only like 6 questions coming from corporate law, but in 2022 it increased to 9, and 2023 it increased to 20 questions coming from corporate law. So, the universities are now focusing a lot on corporate law, which will include your Companies Act, and also you can also expect something from SEBI regulations also. But again, the main focus will be on the Companies Act. Then jurisprudence has been seen a decline in the importance. Previously, if you see 2019 pattern, the number of questions for jurisprudence was really high, but now we can see it's coming hardly 6 to 10 or 6 to 12 questions are coming from jurisprudence, and they are mostly based on a passage. So for Clat exam, there will be several passages that given to the children. There might be a 60% of based on judgments and 40% based on general passages. So for these general passages, you can expect questions on jurisprudence or international law or corporate law. There might be general passages which deal with these subjects. Then miscellaneous we are marked because there were several passages that were based on your understanding about the judiciary, about the independence of the judiciary. So we couldn't put that under the head of constitution, but not under anything else. So there might be miscellaneous passages again based around judiciary or independence, collegium system, things like that. Then lastly, things like IPR, we did not see any question in 2021 or 2022, but for the first time in 2023, a passage came on intellectual property rights, and that too for 10 questions. So usually when in 2019 pattern also, there were questions coming from IPR, but they were all static questions in 2019. Basically, the questions will be what is the year of, for protection of patent, what is the duration, very static question. But in the year 2023, it was based on a passage. So there might be questions coming from IPR, but not that much also, because last time they did not ask anything about family law. So we are taking 50-50 chance here. Then lastly, you need to look into environment law. Environment law is again another mandatory subject that will come for Clat exam. Okay, yeah, done. So, because I have attempted this exam thrice, I would like to provide some exam tips that actually help me to crack this exam. So, first thing, what we would do is a allotment of your time. So, there is 120 minutes. So, what you can do is you can divide your time as 80 and 40. So, in first 80 minutes, you need to read through all the passages and mark the answers that you know for sure they're correct. So first round you can do that, and while doing that itself, you can mark the answers which you are not sure what's the right answer. So mark that for review. So after finish the entire first round within 80 minutes, you can come back and revisit and think about these questions you marked. Within this 40 minutes, you can answer all these questions. So that's what happens is that it also increases your accuracy that way, because you're not going on and writing all the wrong answers in the first instance, but you're just focusing on the correct ones, and then you're coming back for review. And second thing is calculated guess in case of uncertainty. Suppose you don't know any answer, you don't know the correct answer, but what you are definitely know what's the wrong answer. So you can eliminate these wrong options and then somehow take a calculated guess. Third thing is accuracy is the key. So here we have negative marking of minus 0.25. So it's not how many you attempted 120 questions. That's not the deal here. The deal here is you need to get the accuracy of at least 85% because of the negative marking. So if you are looking or aiming for ranks below 200, you need to at least attempt 110 to 115 questions, so that you can at least get AR 200, and you can reduce the questions. If you are not aiming that much, like AR 600, then you can go for 90 to 100 questions you can attempt if you are aiming for AR 600. Then finally, the important thing is all this exam, the pattern itself is based on comprehensions. So because these are based on comprehension, you need to up your speed of reading the comprehension and try to understand or figure out the correct answer from the comprehension. So you need to improve your reading skills. And finally, of course, you need to maintain your patience and avoid any sort of anxiety, because people tend to make a lot of mistake when they come under anxious situations. Okay. Now we have pulled out a model question from Clat PD 2023 paper. So this is a question based on corporate law. Please read the question that's given on the PPT. So the question here talks about the minimum spending obligation on CSR, corporate social responsibility activities under Companies Act. So here, which method can we even apply? We won't be able to guess or take a calculated guess or eliminate any wrong answers. But we need to know it's a static question, so we need to know the answer. So here the answer is B, that is 2% of average net profits. So you can expect direct questions like this in CLAT exam, where you need to know the provisions correctly, because you cannot employ any eliminate methods for this. Can we have the next model question? Okay, so this is another question from the year 2022. So basically, there was a passage given, and we were supposed to give the right answer relating to right to peaceful protest. So if you see the options here, and when I attempted this paper, I did not know what will be the correct answer. So what method I used was, first I eliminated the wrong answers. So because Anuradha Vasin versus Union of India is a landmark case for internet freedom, and when there was lockdown of internet in Jammu and Kashmir, so I can eliminate that option. Then another thing is MC Mehta versus Union of India is usually related to environment law cases, never deals with a peaceful protest or anything. So I can take a calculated guess and again eliminate that option. Now, third is Association for Democratic Reforms, and mostly they deal with election and things like that. So that's why the actual answer here is Amit Sahini versus Commissioner of Police, and it relates to Shaheen Bagh protest that was happening in Delhi. So the correct answer is Amit Sahini versus Commissioner of Police. So you can apply methods like this to eliminate the wrong answers. Okay, over to you, Rindu.
Hi, everybody. Thank you so much, Sukanya. I hope this was a helpful thing for all of you. So, right now, we're going to go into the thing that we had promised you all. We're going to talk about over 40 cases today, out of which 40 of them are going to be from the 2023, from this year as well. We also have a couple of other cases which talks about a couple of other judgments from previous years as well. That is important for your exam. Now, this is a session that would be helpful not only for CLAT students, yes, mainly for your CLAT PG students, but also for somebody who really wants to know what has happened in this year. We've had so many cases. What has the court said in each case? What are the important developments of the Supreme Court? So all of that will be told to you in just about a minute. And one more thing is, the presentation, or we have prepared a PPT, and this PPT will be shared with all of you after the end of the session. So I'm going to be presenting my screen, and please do let me know if it is visible. Is the screen visible to everybody?
Yes, ma'am.
Thank you. And also, we'll be taking up questions as well at the end of the session. But since it's going to be a slightly long one, do give your questions in the chat box and we'll take it up. So without any further ado, we are going to go to the first case of the day, that is Supriyo Chakraborty versus Union of India. A few of you might know, but I hope whoever is appearing for CLAT exam should know this question because this deals with same-sex marriage case. So I'm sure everybody knows about the background. This is basically the accumulation of multiple petitions which talked about legal recognition for homosexual marriages. And here are the issues. One of the main issues was, is the Supreme Court the right forum to recognize a queer person's right to marry? The second question was, is there a fundamental right to marry? Then we are going into the right to enter into a civil union and so on. These are the issues. Let's go into the judgment. Regarding the first question, is the Supreme Court the right forum to decide this question? The court basically talked about judicial review. Now here what you need to understand is there were multiple judgments that were penned down by different judges. This was a constitution bench bench case. So here the first judgment was penned by the current Chief Justice of India, Justice Chandrachud. So here the first question was on judicial review. And because judicial review is an essential element of the doctrine of separation of powers, the court is within its powers to consider whether fundamental rights of a queer persons are being violated or not. However, this was disagreed with by Justice Butt. To the next question, is there a fundamental right to marry? The bench unanimously held that the Constitution does not expressly confer the fundamental right to marry. So here what you need to understand is Justice Chandrachud said that the states are free to make amendments to the laws relating to the institution of marriage. And the bench held that the right to marry is a personal preference which confers your social status. And thus, it is not an enforceable right. This is a very important aspect as far as this judgment is concerned. With regard to queer couples, do they have a right to enter into a civil union? This is a civil union and not a marriage. So in this regard, also the bench gave a verdict which was split in nature. It was in the nature of a 3:2 ratio. And the next question that the court dealt into was, is the Special Marriages Act 1954 unconstitutional for excluding non-heterosexual couples? Non-heterosexual couples means a person who, a man-man relationship or a woman-and-woman relationship. It could even, have transgender persons as well. However, the court said that the provisions of SMA are not unconstitutional because of this. Because court looked into what was the intent here. SMA is a legislation, that too a progressive one, and its intention is to facilitate marriage between persons who are professing different faith. So here faith has a religious connotation, and here gender is not the most important aspect, and therefore SMA has no nexus with the exclusion of non-heterosexual couples, is what the court said. The next two questions were, can the right to marry be read into the provisions of Special Marriages Act? So the court said that the right to marry cannot be read into the provisions of SMA. The next question was on adoption. So here we had two judges who said, yes, it is possible, and three judges said, no, it is not possible. Justice Chandrachud was of the opinion that there is no statistical proof to say that only heterosexual couples can provide stability to a child. But Justice Butt and the others were not of this opinion. And this was one of the concluding questions. Can transgender persons in heterosexual relationships marry under existing laws? And here, the bench unanimously gave the decision that transgender persons in a heterosexual relationship can marry under existing laws and the Transgender Protections Act, which came out in 2019 as well. We are going to the next case. This is Indra Kunwar versus State of Chhattisgarh. So in this case, the court mainly dealt with the importance and the legislative intent of Section 313 of the CrPC. Now, as Sukanya had already mentioned, 313 or aspects of CrPC do come in your Clat examination. So it's very important to look into questions that deal with statutory provisions and what is the latest update or what is the latest ruling on such provisions. 313, 319 of CrPC have been asked earlier as well. So it's important to look into these aspects. So here the court looked into the intent. As you can see, it is very well given here. One is the object of 313 is to enable the accused themselves to explain any circumstances appearing in the evidence against them. Here, what is the court trying to do? This is a dialogue between the court and the accused. Who does this benefit? This process benefits both. It helps the accused in saying their side of the story, according to them what happened, and it helps the court in arriving at a final verdict. 313 is also based on your principle of natural justice or the alteram partem as well. So this would be the second case. Moving on, this is yet another important case. This is X versus Union of India. This was pronounced very recently. So as you can see, we have here, this is decoding Supreme Court's full bench verdict in the 26-week pregnancy case. So if you all remember, there was another case which was very progressive in nature. This judgment, however, is not as progressive, but let's see why it was that way. So here, it was the relief that was sought here was with regard to termination of 26 weeks of pregnancy of a person, a woman. And here the court said that the termination of pregnancy sought is beyond the statutory limit. What is the statutory limit? According to the statute, 24 weeks is permitted under the Medical Termination of Pregnancy Act. So if you want to exceed that, either the fetus must have developed a substantial abnormality or multiple abnormalities, or the termination must be necessary to save the life of the woman. Here, both these conditions were not met, and therefore the relief sought by the petitioners was not granted. The matter was originally referred to a two-judge bench that gave a split verdict, and that's how it came before a three-judge bench. Here also, there was this concept of viable fetus as well. The aspect of what is a viable fetus was also looked into. So that also would be important if you're looking into this judgment. The next question would be Yashpal Jain versus Sushila Devi. Here it is, the court is basically looking into the delay or the reasons for delay in civil trial courts. And here, if you look at the facts, it's quite simple. But what is more interesting is what the court said with regard to civil trial. So according to the court, lack of strict compliance with the CPC provisions. CPC was enacted by, why was it enacted? So that the civil trial happens in a smooth and easy manner. There are no hiccups in the process. However, the court was of the opinion that strict compliance of the provisions is not happening, and there was a misuse of court processes. Another problem was lengthy evidence and arguments and non-utilization of CPC provisions. Then we also have frivolous and vexatious litigation. Vexatious litigation here means false, cases that's being filed against people, or frivolous cases where you don't come with clean hands, where you have an ulterior motive. That is what the court is trying to tell here. The next is lack of adequate training and appropriate orientation to judicial officers as well as lawyers. Another reason was the lack of prioritization of cases. You need to prioritize what is more important. You cannot deal with everything, right? So that is the point that court is talking about here. Then lack of accountability and transparency. Because here, is anybody keeping a check on how many cases are being, what is the pendency rate? Of course, we have think tanks and all of that, but is there a body? No. That's exactly what the court is trying to talk about here. And over-tolerant nature of the courts below. These are roughly the 8 points that court said as to why the provisions of CPC are not being followed, why there is a lot of delay with regard to pendency of civil trial. Next, we are coming to yet another very, very important case of 2023, which is otherwise known as the Jallikattu case. This is the Animal Welfare Board of India versus Union of India. So what you need to remember is that there was an earlier decision which came out in 2014. And this was, so you need to understand the background of that. So basically, there were three states which had animal racing games. So that was prohibited by 2014 because of the violent practices, because, the practices were too violent, and also the rights of animals. All these things were taken into consideration. There was cruelty of animals. And because of all these reasons, what the Tamil Nadu government did was that they came out with an amendment in consonance with the 2014 judgment. And this was challenged before this court, before the Supreme Court. And this was the primary issue before the Supreme Court this year. Let's see what the court said. Roughly, let's just go through the issues. Whether the Tamil Nadu Amendment Act, does it perpetuate cruelty to animals? The second question was, would it receive protection under Article 29? Everybody quickly recall what Article 29 is in your mind while I'm doing this. Also, is the Tamil Nadu Amendment Act contrary to Articles 51AG, 51AH, and violation of Articles 14 and 21? All right. So when we are dealing with judgments and cases, you will find these section numbers. Try to mentally recall, because you have the exam in very few days. So it is important when a session like this happens to jog your memory, understand, or keep the constitution next to you, or as and when something is, we're dealing with cases, quickly go through which article it is so you can understand it quickly. So these are the issues that the court dealt with. So the first contention was rejected by the court, saying that the petitioners argued that the state legislature does not have the jurisdiction to bring this amendment. So this was rejected by the court. And the court also said that a large part of these pain-inflicting practices, which means the earlier acts of bullock cart racing, Jallikattu, they were performed in a very cruel manner before the pre-amendment, that is before 2017. And these have been substantially diluted, which means these issues of cruelty have been taken. It has been diluted by the introduction of these new statutory instruments, which means the amendment itself, the 2017 amendment. And the court also said that since the Amendment Act already received the presidential assent, the court did not see any reason or any flaw with regard to the state action. We have culled out an important paragraph from the judgment here, which you can read once you get the PPT. The next is whether protection of Article 29 would be given to the Amendment Act. So the court was like, whether Jallikattu has become an integral part of Tamil culture or not requires greater religious, cultural, and social analysis. And it was not the Supreme Court's duty to look into that aspect. And the court was of the view that, see, there has already been, the legislature has already decided, yes, it has protection under Article 29. And because the legislature has said this, the court was of the view that, see, we don't have to look into that. Legislature has already decided that. So we don't have to look into that aspect again. Okay? Now, the next question that the court dealt was the protection of Articles 51AG, 51AH, and whether it is violative of Articles 14 and 21. So the petitioners try to argue here that animals also have fundamental rights apart from legal rights. So the court said that it would not be prudent to look or go into this kind of judicial adventurism. Please note the term judicial adventurism to bring bulls within the said protected mechanism. The court was basically of the view, see, for example, a bull or an animal is missing. Would you come to the court with a habeas corpus? Or would you come to the court with another writ? That is not possible, because animals don't have that kind of rationale to understand that they have a right. So how can a person who does not understand that they have a fundamental right be given this right at all? That is what the court is trying to tell here. So because of these reasons, the state amendments, Prevention of Cruelty to Animals, Tamil Nadu Amendment Act of 2017, and Prevention of Cruelty to Animals, the same Act, rules of 2017, The court said did not violate the constitution, and also the Supreme Court's earlier decision. So not violative of the constitution and not violative of the Supreme Court's earlier 2014 decision as well. Next, we are coming to the case CBI versus RR Kishore. So here the important question was whether Section 6A of DSPE was violative of Article 20, Clause 1. We have the background here. The court held that Section 6A of DSPE Act is part of procedure only in the form of a protection to senior government servants alone and does not introduce any new offense or enhances punishment or sentence. The court also looked into the term void that was used in Article 13(1) and the prohibition on abridging the rights under Article 13(2). That is, it talks about law, right? The court noted that Section 6A of DSPE would be void. The court held that the declaration, which was in which case in Subramanian Swamy, will have retrospective effect and clarified that Section 6A of DSPE will not be enforced from the date of insertion. The next question or the next case law that is important is CPL Ashish Kumar Chauhan versus commanding officer. Here, the court was looking into the standard duty of care or negligence here by a military hospital. So what you can see here is that the court held that the IAF and Indian Army were vicariously liable jointly and severally for the medical negligence of breach of standard duty of care. So you have negligence here, joint and several liability. You have another concept here, standard duty of care. And because of all this, the appellant, as in who filed the appeal before the court, had a direct cause to his health. Because of this, the court awarded a compensation of this amount to the appellant. The next case that we have here is People's Union for Civil Liabilities versus State of Maharashtra. Here, the court basically asked the MHA to prepare a very comprehensive manual on media briefings by police personnel. So you need to understand here, what do you mean by media briefings? On the issue of modalities to be followed by the police during media briefings, the court highlighted media reporting is very important for what? For public interest. Please also remember, I'm asking you a question. In which case did the Supreme Court say that sunlight is the best disinfectant? Very important. Try to connect these judgments while you're studying as well. So you have a very systematic approach to your learning also. Moving on, the media has a fundamental right to speech and expression under which article? Article 19(1)(a), to disseminate news and information, while the consumers have what right? They have the right to receive fair and unbiased information. This is very important. But the court also said every accused at the stage of trial is innocent because innocent until proven guilty and has a right to fair investigation by the police and media reporting in a very, it cannot be in a biased manner because that would tarnish his or her image. Next, we have Union Territory of Ladakh versus Jammu and Kashmir National Conference. This was again on the plough symbol. And here the court is talking about, I'm sure everybody knows about this because this was widely reported by the media. This was also a very important case of this year. Here the court is talking about the importance of an election symbol during electoral proceedings as well. It's very important to look into this aspect from both, from a news perspective and also from a legal perspective, because ultimately we're giving a legal exam. The court here said that the decision of the appellant cannot be arbitrary or unreasonable. The request by JKNC should not be denied merely because there is no provision empowering the appellant to confer election symbols to local parties. Okay. So you can see 4 headings over here, and the court noted that these 4 would be a genuine request for a ground for denial. One, if it is in violation of the law, if it is outside the jurisdiction or the capacity of the concerned authority, if it causes any kind of prejudice to any stakeholder, or militates public interest. Basically, anything against public policy if it's in violation of law, etc. All right. So the court, while stating this, the court also made this very important paragraph. Please go through it. So here the court set aside the election process and directed the EC to hold them afresh. The JNKC was allotted the plough symbol and the appeal was dismissed with cost. The next case is Balwan Bhai Sombai Bhandari versus Hiralal Sombai contractor. So here again, you need to understand what is civil contempt. The court is going into this case of what is a civil contempt, what are the different positions. Here the court said this: willful breach or disobedience of an undertaking by a counsel or advocate to a court amounts to civil contempt. Please note there are two kinds of contempt. One is civil, one is criminal. Here the court is dealing with civil contempt. The undertaking given to a court attracts the provisions of Contempts of Court Act 1971. You also need to understand what is a court of record. The Supreme Court and High Courts are court of record. Please tell me why they are courts of record, and tell me what are the powers. If you want to, you can use your chat option and please give your answers there. Moving on. The court can declare transfer of property as void during litigation to uphold the majesty of law. Now, contempt is between whom? There are only two parties here, right? One is the court, one is the contemner. Thus, a beneficiary of such transaction has no right to be heard in a contempt proceeding. And also, if there is a contempt, and if you're giving your you're giving your apology, that will not be accepted if the conduct is serious and affects the dignity of the court in itself. Ultimately, it's up to the court whether to accept your apology or not. The next case is Ilavarasan versus State. So in this case, it overruled a judgment, S. Balakrishnan Pandian versus SPF Police 2014. This talks about Section 7A of HMA 1955. So this is with regard to, if you remember, there was this case on Tali, right? That is the question here. Solemnization of marriage under Section 7A of the Hindu Marriage Act. That is the main issue here. So the court said that the provision merely required that spouses to declare and express to each other their willingness to take each other as spouses and symbolically garlanding each other and tying a tali. So this was, there was this provision that was inserted into the Tamil Nadu Amendment Act, which applies to any marriage between two Hindus. So the court also took note of the individual's right to free choice as a part of right to life as well. The court also noted something very important here. Advocates can volunteer to solemnize marriages. However, this should not be done all the time, because the court said then the advocates' chambers would be turned into matrimonial establishments, and you don't want that, right? So you can, advocates and lawyers, they can act as witnesses to solemnize marriages in their personal capacities as friends or relatives, and not in their professional capacity. The next one is again an important question. This would again come under your family law aspect. Very important case, Shilpa Sailesh versus Varun Srinivasan. So here the court is looking into the powers of the Supreme Court under Article 142, inherent powers of the court, right? So here we have this theory, irretrievable breakdown of marriage. Please ask yourselves, are you aware of the theory? Do you know what the theory talks about? Let's get into the case. So here the court was looking into what is the power of Article 1, that the Supreme Court has under 142. Can 142 be decided to decide all divorce cases at all? The court said that the party should not be permitted to circumvent the procedure by resorting to writ jurisdiction. You have a procedure. There is inherent powers of the Supreme Court, but you cannot go beyond the procedure that's already established by going to your writ court. So Supreme Court That would be Article 32, and 226 would be for your high courts. The power under Article 142 is tempered or bounded by restraint, which must be exercised on fundamental considerations in general. So that would be your fundamental rights, secularism, federalism, and other basic features of the Constitution of India. And these are the following grounds to be considered while granting divorce under the powers of the Supreme Court, under which Article 142. So please go through these. It's very, it's given for your easy understanding. The next important aspect that this court looked into was, can mandatory waiting period or the cooling off period of 6 months for divorce by mutual consent be dispensed with? So the court looked into the objective of having this cooling off period, right? The court said that this time is given so that the couple has some time for themselves to introspect and consider whether they want to separate, how serious are they on this decision before a second motion is moved, and also to ensure that there is a hope for marriage to work out. Next is Government of NCT Delhi versus Union of India. So there was a notification here issued by the MHA. Again, another very important case as far as your ClapPG is concerned. Here you need to understand three important terms. One is public order, police, and land. All right. So there was a 2018 judgment also that was put into with this. So what the court did was it upheld that 2018 judgment. The court said that the Legislative Assembly of the of Delhi has competence over entries 2 and 3. Please ask yourself under which schedule the lists would come, what list 2 and 3 would be. And the rest of the matters are very well given out here. And the executive power of NCTD with respect to entries in list 2 and 3 shall be subject to the executive powers expressly conferred upon by the Union, by the Constitution, or by a law enacted. This case also looks into Article 239A, capital A, 3. That is also very important provision as far as is concerned. Now, NCTD has legislative and executive power over services, except for services related to public order, police, and land. That was the, what the court said in this case. Next, we are going to the next case, that is Irfan versus State of UP. I hope all of you are with me. I hope my pace is fine. If you have any issues, do let me know. And do you have any questions? I'm sorry, I cannot see well. Just give me a moment. I'll just... All right, let's move on because we have a lot of cases to cover. So let's move on. So next case is Irfan versus State of UP. So in this, the court looked into factors of dying declaration. So again, when you talk about dying declaration, very important topic in your criminal law. It's very important. So here, there is a justification for the sanctity and presumption that is attached to a dying declaration. And the court said that is twofold, ethically and religiously, and also from a public policy perspective as well. So these are the factors. So you have 11 of them. You don't have to by heart these factors. Understand what they're talking about. Like, for example, the first one is whether the person making the statement was an expectation of death. Second one, whether the dying declaration was made at the earliest opportunity, the rule of first opportunity. Please ask yourself, do you know this rule? Ask yourself, make notes if you don't know it, and read up on it. Whether there is any reasonable suspicion to believe that dying declaration was put in the mouth of the dying person, and so forth. And also these factors are not, these are not final. You can keep adding on. This is just this is an exhaustive list, but not a final list. All right. And this is with regard to these factors should be considered to sort of check the veracity or the weight of the dying declaration. And also with regard to, is a dying declaration admissible in a court of law or not? These are the 11 questions or the 11 aspects that you would have to consider. Moving on, we are going to the next case, that is Moser Bear Karamchari Union versus Union of India. Apologies if I'm not pronouncing the names rightly. I'm so sorry, but let's move on. So this is with regard to section 327, subclause 7 of the Companies Act. And the provision was that, or the challenge basically was that this provision is unconstitutional. Now, what does this provision talk about? It's basically on the waterfall mechanism. Please ask yourself, do you know what the waterfall mechanism is? And with this, please ask yourself, do you know what IBC is? Insolvency and Bankruptcy Code 2016. Till now, no questions have been asked from IBC, but it's good to know the provisions. It's good to know the provisions, what the Act generally talks about, because here section 53 of IBC also and section 36(4) also comes into play. Important to understand here what the object of the 2013 Act. So the Companies Act was amended in 2013. I hope all of you know that. And the court is basically looking into the Amendment Act. And in the Amendment Act also, sections 326 and 327 was not removed with. It was kept in the Amended Act of 2013 as well. The court looks into that aspect. So then in this point, again, the court is looking into liquidation, again, about the waterfall mechanism generally. While examining the difference in the waterfall mechanism provided in the Companies Act 2013 and the code, which is IBC, the court said that section 326 of the Companies Act deals with overriding preferential payments which have to be paid in priority to all debts. So waterfall mechanism is nothing but at the time of liquidation, you have an order, and in that order, you will be paying all your, so you have limited money, right? Because at the time, and you will have so many debtors, you will have to pay some money to the liquidator itself. As of now, under IBC, we have an insolvency professional right now. Okay. So you will have to pay that person. You will have to pay the government if you owe them some money. Then you have your creditors, your financial and your operational creditors. So there is a priority that is given, and that is your waterfall mechanism. So that's what the court is talking about here. Every change in the waterfall mechanism is bound to lead to cascading effects on the balance of rights and interests of secured creditors, operational creditors, and even the central and state government. So if you change the priority order even by one step up, so somebody has to come down. So that basically disturbs the balance of the order. That's what the court says. Next one is Meenal Bagarwa versus Naveen Sharma. In this case, again, a very interesting set of facts. This is basically a contempt case. When you come to it, it is a contempt case, but nothing new. It's very similar to normal contempt case, but what is more important is this doctrine of the principle of comity of courts. Principle of comity of courts, also known as judicial comity, is basically a concept in law that reflects mutual respect and deference that courts of different jurisdictions, basically countries, not your internal courts, but courts of different jurisdictions have for each other's decisions. It is based on the idea that it is generally more efficient and just for courts to recognize and enforce the judgments of other courts rather than relitigating on the same issues. It's basically on acceptance and tolerance at an international level that the judiciary has for each other. Okay. So please do go through this, principle. Next is the case. It's an arbitration case, NN Global Mercantile Private Limited versus Indo Unique Flame. Till now, not many arbitration questions have come, but since Clat PG the consortium keeps changing the pattern a little bit every year, it's good to be more aware than not knowing. It's better to be safe than sorry. So this is with regard to non-admissibility of unstamped arbitration agreements. So good to have an idea of what this case exactly said. It is based on sections 33 and 35 of the Stamp Act. And also you have provisions of the Arbitration Act as well, obviously. We're moving on to the next case, that is Madhyamam Broadcasting Limited versus Union of India. Again, this is a very important case with regard to the Constitution because it talks about your fundamental rights. So in this, the court says that denial of a security clearance to operate a news channel is in violation of your fundamental rights to carry on, free trade and also freedom of speech and expression. So here the court was looking into the aspect of when you're talking about involvement of national security considerations. Let's say there is a threat and it's a threat against national security. The executive or the government cannot arbitrarily go and say that, okay, you cannot revoke licenses, especially of news agencies or news channels, right? So the court has laid down two tests here. Whether there is material to conclude that the non-disclosure of information is in the interest of national security, 1. 2, whether a reasonable, prudent person would draw the same inference from the material on record. So this basically led to the court laying down something, i.e. the procedure for conducting public interest immunity proceedings. Please understand what public interest immunity proceedings are. And the court is also dealing with sealed cover procedure. And in many cases, the court has, in open court as well, many judges of the Supreme Court have said, we are not, encouraging the practice of sealed covers. So do look into that aspect. Then the court also talks about how sealed cover procedures are against the principle of natural justice as well as open justice. All right. And in order to safeguard the claimant against a potential injury here to procedural guarantees in public interest immunity proceedings, the court also has the power to appoint an amicus curiae. And these are the powers that would be given. So the previous case, you have a couple of important, things to look into. One would be obviously your fundamental rights aspect. Then you have the national security consideration. Basically, a test is being laid down. And after that, the court is looking into public immunity proceedings, public interest immunity proceedings. That is also something that you have to look into while reading the case. And sealed cover, procedures, how it is against natural justice and open justice. All right. Next is Anup Baranwal versus Union of India. In this, the appointment of members to ECI, Election Commission of India, was challenged. And it was challenged on the ground that it is incompatible with Article 324, Clause 1. Okay. So here the court looks into, obviously, so whenever something is challenged on the strength of or against a particular provision, the court will definitely, by rule of thumb, go into the legislative intent of that provision. Same thing has happened here. The court has looked into Article 324, Clause 2, and says that it does not provide for consultation with anyone, and it appears to place the power to make appointments exclusively with the executive, as the president is bound by the advice of the prime minister. Here, what are we talking about? This is a legislative intent. The court is trying to interpret this provision based on the constitutional aspects. And here it is to understand whether, it is advisable to extend the protection that is given to election commissioners to safeguard and ensure the independence of election commissioners as well. All right. So important to look into these aspects. Here also we had 2 judgments, and there was in the concurring opinion, there were 2 judgments, but both of them were concurring. There was no dissent. So here one aspect that was highlighted was the grounds for removal of election commissioners shall be the same as that of chief election commissioner, like how it is for the judge of a Supreme Court. That would be the same. And the conditions of service of election commissioners shall not be varied to their disadvantage after appointment. So this deals with Article 3 to 4, Clause 5. So you will have to look into 3 to 4 in general to have a picture, even though only a specific aspect or provision is challenged here. But the court is looking into the entire provision. The next case that we need to go through is Kaushal Kishore versus State of Uttar Pradesh. So here there was an SP leader, Azam. So it was a little controversial case at the time when it was reported as well. In 2016, there was an unfortunate gang rape of a minor and the mother. And this particular political leader said that this was nothing but political conspiracies. So here the court is trying to talk about the issue of freedom of speech of public functionaries. So you would have your Article 19 clause, you would have your 19 clause 1A, and you would also have Article 21, because right to life and personal liberty. So in this case, the court has actually penned down a very progressive and responsible judgment. Here we have a dissent by Justice B.V. Nagaratna, who talks about the constitutional impact that this has. Basically, it's the collective responsibility of a social concept. When you talk about 19(1)(a) of ministers or public functionaries, it is a larger degree of responsibility that's bestowed on them. And therefore, Justice Nagaratna has remarked that the failure to carry out duties enjoined upon the state under statutory law to protect what? The rights of citizens could have the effect of depriving a citizen of his right to life and personal liberty. So basically, when the state is not doing their function, not only are they not doing their function, you are actively depriving a citizen of their fundamental rights. And Justice Nagaratna had also dissented to say that only stray opinions of minister will not attract collective responsibility. So she is explaining this a little bit. So what she's trying to say is that a minister makes statements in two capacities. One, in his personal capacity. Two, in his official capacity. That means as a speaker or, within the office and as a delegate of the government. It is no-brainer that in respect to the former category of statements, there is no vicarious liability because it is individual capacity. The latter category of statements may be traceable to any affair of the state and may be made with a view to protect the government. So here the concept of vicarious liability also comes to the picture. And Justice Nagaratna also talked about how it is very important to have a proper and effective, like a systematic legal framework to define the acts that would amount to a constitutional tort. Please ask yourself, are you aware of constitutional tort? Do read up if you're not sure about it. And it also talks about the manner in which the same would be redressed or remedied on the basis of judicial precedent. We are coming on to the next case. We're moving on. I hope everybody is with me. Do not worry about getting the notes because you will be getting the PPT right after the session tonight itself. Don't worry about it. If you want to make notes while the session is going on, you're free to, but you don't have to. You will be getting the entire copy. And moreover, if you want a detailed list of cases, these are cases predominantly from 2023. We've have different courses from from 2016 to 2023, we have cases, we have constitution, contracts covered from a very strictly, Clat PG perspective. If you're aiming for something good, we have that with us. Do check out our store. We have provided the link in the comment box. Do check out our store and do check out if you really want something. It is, at this point, we are not even, we want maximum people. We want our venture to reach maximum people. We want law to be accessible or NLUs to be accessible to maximum number of people so that people are encouraged to give the exam. They are also given an opportunity to study in national law universities. It shouldn't be something for the elite. That is the concept, or that is the idea as to why we started this. So please do check out, and we hope you are liking the session so far. We have almost completed half of the session. We still have about, over 20 plus cases to go on. So let's continue. I hope everyone is with me. Do give out a thumbs up if you are understanding and if you're able to follow. I'll wait for a sec. All right. The next case is Common Cause versus Union of India. Here the court was talking with regard to advanced medical directives. So the court appoint that advanced medical directives would be fruitful or would be effective to facilitate the fructification of the sacrosanct right to live with dignity. The court said that this directive will dispel many doubts with regard to the relevant time of need during treatments of a patient. That apart, it will strengthen the mind of treating doctors as to whether they would be able to ensure, after being satisfied, that they are acting in a lawful manner. However, the court said that AMD, or advanced medical directives, it cannot operate in abstraction, and therefore you must have proper safeguards in place while you have the AMDs. Next is your Orissa Administrative Tribunal Bar Association versus Union of India. Here, what was questioned was the OAT, that is Orissa Administrative Tribunal. Here, the court said that OAT being abolished, or the fact that the state government abolished the OAT, is not unconstitutional, and it is well within the powers of the state government as well, because it is not shall that is written, but it is may. It is discretionary and not mandatory when you look at the act itself. And it is not arbitrary, it is not unreasonable. And the court said that it's not like there is no other forum for the citizens within Orissa to go. They can directly go to the Orissa High Court. So even if you don't have an administrative tribunal, it is not arbitrary, not unreasonable. It does not violate Article 14 of the Constitution. So here the court said that the fact that the OAT, or the Orissa Administrative Tribunal, was struck down, it's a policy decision. And when you are talking about policy decisions, you cannot ask all the members of the public at large whether, or you cannot grant them an opportunity, because public policy or such decisions are completely under the strict domain of the legislature. And because of that, this is not possible, is what the court said. Next is Nabam Rebia versus Deputy Speaker. So this is also another important case. This is important because the court referred this judgment to a larger bench for reconsideration of the accuracy of this judgment, because it held that the speaker could not initiate disqualification proceedings when a resolution seeking his removal is pending by the court. So these are your, this is what the court said. One is interim measures to ensure that the objective of the 10th schedule, do ask yourself, what is the 10th schedule? The Supreme Court will not decide on the disqualification of rebel MLAs, validity of actions taken in the House by rebel MLAs. Please go through this. This is an important aspect. The court also said that appointment of new party leader and chief whip is illegal. The next case that we are going through is Union of India versus Union Carbide Corporation. So this basically everybody knows, so I'm not going to, go deep into it. It was basically the MIC gas leak. So there was a judgment that came in, and that also becomes important, because when you're talking about environment, this case becomes important. And there are cases from environment with regard to, when you look at your Clat papers. So this also becomes an important case. So in this case, the court dismissed the petition that sought an enhancement of compensation for the victims of the Bhopal gas tragedy. The court said that the settlement amount was sufficient to compensate the victims, as it was admitted, in fact, that the proceedings that the amount of settlement was in surplus than the actual requirement. So that's what the court said. The next case is on the powers of BCI. This case is BCI versus Rabi Sahu. In this case, what happened was, the main or the most critical question here is, can the Bar Council of India sort of de-recognize a law university and say that, okay, if this person gets a degree from a de-recognized or an unrecognized university, they have an LLB degree, and does the Bar Council have the right to say, no, this person cannot enroll or become an advocate? The court says yes, because the court took into these cases, Bar Council of India versus Bonifoy Law College, which was again a 2023 case. And in that case, it was held that the case of V. Sudhir did not lay down. That is another case, V. Sudhir, you can see it here. V. Sudhir versus Bar Council of India, it's a 1999 decision. In this Bonifoy case of 2023, the court said that V. Sudhir did not lay down the correct position of law, as BCI's prior role to enrollment cannot be ousted by Section 49. The court concluded that the High Court, this was an appeal, so the Orissa High Court's decision was wrong to direct the enrollment of the writ petitioner as an advocate, because that power would directly fall under BCI's purview. Next is Aurelino Fernandez versus State of Goa. I'm really sorry if I pronounced the name wrongly, but we'll have to go ahead. This is with regard to the POSH Act. The court basically gave out strict, proper, extensive guidelines and directions, not guidelines, directions for the implementation of the POSH Act. Again, an important aspect for you as far as your PG exam is concerned. The court said that an improperly constituted ICC, that is your Internal Complaints Committee, LC or IC. So these are the, your bodies that you have under the POSH Act that have to be set up in every office when it meets the respective threshold. So it would be an impediment in conducting an inquiry into a sexual harassment complaint. So the court also relied on a newspaper report, and that's when the court was of the view that 16 out of 30 national sport federations have not constituted ICC, and sports federations would directly come under the government's wing. But unfortunately, the court took this into consideration and gave out directions. That also becomes an important case for you. The next one is Sabir Ali Khan versus Said Muhammad Ali Khan and others. So this is with regard to Waqf. This is a little technical, but we have simplified it for you here. So the main question here is there a valid Shia Waqf and whether it was registered? So we haven't had, again, this would come under your personal laws, but we haven't really had a lot of questions from personal laws. Family law, yes, but when you really talk about, because we have questions from maintenance, adoption, etc. From this aspect, not really, but still we do feel it's an important case, so we have given it. So you can go through it, because here there's this concept of acquisition of title by adverse possession. It's important to understand what the concept means, what the doctrine means. The next is Foundation for Media Professionals versus Union of India. So this is not a final judgment. This is basically, this is still sub judice. The Union of India, or the center, was asked to form guidelines for seizure of digital devices by investigative agencies. So we have also mentioned the guidelines. So these are the guidelines that the academicians tried to give out. These are their suggestions. What exactly is sought from an electronic device and why must be produced in writing. The device seized will be first examined by an independent authority in the presence of the owner/agent. So these are the things that they've suggested. Compelled disclosure of passwords is prohibited or forbidden unless any statute expressly allows for it. So these guidelines that were proposed by the petitioners, they were allowed in interim, as in This is an interim measure until they can be replaced with a more permanent measure that may come out from court directions or through a legislation. So the court has asked the union to look into this. Meanwhile, these guidelines would be in order. The next one is Vivek Narayan Sharma versus Union of India. This is the demonetization case. The Supreme Court upheld the centre's demonetization scheme in a 4:1 majority and held that demonetization was not, inversely proportional. It was proportionate to the union's stated objectives, and it was implemented in a proper and legal manner as well. So Justice Nagratna gave her dissenting opinion in this as well. So you can go through this. So the court is talking, the majority is talking about the central government has a right of initiating demonetization, but it can only be done by way of legislation and not by way of issuance of notification under Section 26(2) of the RBI Act. This was Justice Nagratna's dissenting opinion. And next we come to Jasbir Singh versus NIA. So here the court said that obtaining a sanction from competent authorities, it's not part of the investigation. The court denied, so there's a concept of default bail, right? When do you have default bail? When the charge sheet is not filed within the mandatory period, that is 90 days within CrPC. So here the court refused the right to default bail on the ground that a charge sheet filed before the expiry of mandatory period without obtaining sanction is not complete, because here the bench tried to differentiate sanction and investigation, saying that obtaining sanction from a competent authority is not part of the investigation, is what the court said. So the remaining cases will be dealt with by Ms. Sukanya.
Thank you, Ritu. Can we please continue the presentation? Okay. So I'll be dealing with the remaining cases. Rintu already dealt with really important cases in the year 2023. So first case here is Indira Jaising versus Supreme Court of India. So Indira Jaising is a very famous senior advocate. So this case deals with the procedure of giving the designation of senior advocates in the Supreme Court. So the Supreme Court noticed that several times what happened, even if there were a cut-off time, and still the application went through the ballot, which is not allowed, right? So the Supreme Court came up with many guidelines to ensure transparency in the procedure of giving the designation of senior advocate in the Supreme Court. Can we have the next judgment? So these are the guidelines which the Supreme Court suggested. So basically there's a procedure about the interview, and the court also told that there is an age limit of 45, and they said just because someone is below the age bar of 45 does not mean that application should be rejected, and under exceptional circumstances they can still be considered to be having being a senior advocate. Rintu, can we have the next slide? Now, this is another judgment. It's Jaya Thakur versus Union of India. So, in this case, the ED director, Chief Sanjay Kumar Mishra, his term was extended for another period. So, this petition is against this, extension of his tenure as the ED chief. So, they said that this is against the Supreme Court judgment in Common Cause versus Union of India 2021 judgment. However, the Supreme Court allowed him to continue to hold the position because of the FATF. So it's an international body, Financial Action Task Force. So because they have to, have a license with the FATF, and they cannot just remove someone such as important position of chief of ED itself, just like that. So that's why they consider that let him, stay in his post till 31/7/2023, and they allowed that. Another issue was they were challenging certain provisions under Central Vigilance Act and Delhi Special Force Establishment Act, and the Supreme Court held that you cannot just come and raise the grounds of unconstitutionality of these acts without any actual grounds for unconstitutionality. So they dismissed all these challenges to the constitutionality of these acts. Yeah. So this is a very recent judgment. So this is We the Women of India versus Union of India. So this case is a very small case, but it deals with a very important concept of support persons. So the court held that under the POXCO Act, that the state has the obligation to provide support persons to the victim under POXCO Act, and it should not be an option for the parents to whether to choose to have or not have. And this right of claiming the assistance of the support person should be conveyed to the parents and the victims of under POSCO. So the Supreme Court directed them to formulate model guidelines with respect to Section 39 of POSCO. This case, Indian Medicines Pharmaceutical Corporation versus Kerala Ayurvedic Corporation Society. Sorry, Shreya, can you just text? Yeah. Can you please comment what the issue is? Shall I continue with the presentation, or is it visible for everyone? Okay, can you guys hear me now?
Yes, ma'am. Your
Yeah,
voice is
okay.
audible.
Okay, thank you. So this case, Indian Medicines Pharmaceuticals Corporation versus Kerala Ayurvedic Cooperative Society. So this case mainly deals with government contracts and whether you should follow the procedure of inviting tenders. So usually, how the government awards contracts to the supplier is first they will, you have seen in papers also. First, there will be a tender. You'll invite them, and they should come with a bid, and that's how you award contracts. And the why it's so useful is that first of all, you get so many options. Second thing, at a cost effective price, you get a better supplier. So that's the main advantage of all these things. But the Supreme Court held that the government is not looking here to maximize the profit. He's not a businessman. So what they're doing is they can actually deviate from the procedure of tender, issuing tender and granting it. But at all times, when government is entering into this contracts, it should not be arbitrary. So Article 14 must not be violated when government is giving contracts or when they are deviating from the procedure of calling for tenders. So the court held that just because the government deviates from the route of tender or public auction, it does not mean it's arbitrary, but the reason must be justification and the reason for such deviation must be given by the government. Here the main case dealt with some under Ayush there were some certified. Can you just go back into to that slide? Yes. One more slide, please. Yeah, so IMPCL was Ayush, under Ayush, IMPCL is recognized. So they were only preparing things from IMPCL and we're not considering other Ayurvedic outlets. So that was the main issue here. And the issue was that they didn't call for tender and everything. And this is what the Supreme Court held, saying it's not violated of Article 14. Okay, can we have the next slide? Okay. This is a very important judgment from family law perspective. It's Revan Siddhappa versus Mallikarjun and others. So in this judgment, basically deals with illegitimate child or child who's born out of not a valid marriage. That means a void or avoidable marriage. So the question here is, if this child who's born out of this void or avoidable marriage, will they get the share to the parents' property in the Hindu family property as per Muttakshara law? So the court held that such child will get the right to the parents' property, even though he or she is coming out of a void or avoidable marriage. But however, they will not have any right over other relatives of these parents if it's under void or avoidable marriage, but only to the property of the parents. This judgment, Raju versus State of Bihar and others. So here it deals with premature release of prisoners. So remission is a procedure where before their the period of their sentencing is completed, you'll release the prisoners based on good behavior or other factors. So the question here is basically it's the power given to the government. So when the government exercises this power under CrPC, they should take the opinion of the trial judge while they are granting a remission or something. So here the Supreme Court held that this person was in jail for like even after 24 years, but still he was not granted remission solely based on the opinion of the trial judge. So the court held that you should not just use a mechanical formula by just taking the opinion of the trial judge, but also apply your mind. The government should also apply your mind and also take consideration of the new factors that came, such as good behavior and whether this person is a threat to the society, changing times, family relation, or even their health. So these factors should also be taken into consideration by the government before rejecting a plea for revision. So section 432 clause 2 under CrPC deals with this remission. Okay. Let's go. Now this is Asfaq Aslam versus State of Jharkhand. So in this case, it deals with the court told in this case that there are not many, they're not following the guidelines laid down in Arnesh Kumar versus State of Bihar. So now this is a very important judgment that you should keep in mind, Arnesh Kumar versus State of Bihar, because very important guidelines were framed by the Supreme Court in this judgment, and they were supposed to be followed by all the lower courts while granting bails. So here the issue is, when you are granting anticipatory bail, what are the important factors that you have to take into consideration? So first is the nature of the offense and how serious the offense is. Second is whether this accused, they are able to influence the evidence, or they are able to disrupt the entire process of investigation. Third is whether they are going to run away from this or likely to flee from justice. So these are the things that they take into consideration while you are granting or rejecting a bail application, right? Anticipatory bail. So in this case, the facts were such that it wasn't that the seriousness of offense was not that high or anything, but still the High Court went ahead and rejected the plea for anticipatory bail just based on a mechanical formula. So the Supreme Court, can we have the next slide? Yeah. So here as you can read here itself, the matter does not relate to a big criminal offense. It was not that big. That still the anticipatory bail was rejected by the High Court. So the High Court just mechanically rejected. And the issue with what happened in Arnesh Kumar versus State of Bihar is, nowadays in the jails there are a lot of under trial prisoners. Just like they weren't even given the chance to bail and things like that. So because of that, these conditions were issued by the government. Okay. Now this case is also very important. It's Mukesh Singh versus NCT Delhi. So this is deals with test identification period. Test identification period, basically when some crime happens and you don't know who the accused is, so you will line up all the accused and the witness has to identify this person. Right? So under test, this person was accused for murder and everything, and then the issue here is whether this test identification period itself, does it violate Article 20 Clause 3 of Constitution? So Article 20 Clause 3 of the Constitution deals with protection against self-incrimination, that you cannot be forced to become produce evidence against yourself. So they are saying whether this the very factor, because Section 54A under CrPC, it was added later by amendment, it mandated for test identification period. So the issue here is whether this the section under CrPC itself violates Article 20 Clause 3 of the Constitution. The Supreme Court held that it does not, because there is no, and just because the accused is not giving his consent to be part of test identification period does not mean there is a coercion or there is actually against self-incrimination happening here. So yes. Okay. So the next judgment here is Janhit Abhin versus Union of India. This is a constitutional bench judgment. Here the issue deals with the validity of the EWS reservation. So under 103rd Amendment, two clauses were inserted. Clause 6 under Article 15 and Clause 6 under Article 16. That's for education and employment. So basically, you are reserving 10% limit, ceiling limit, other than SC, ST, OBC. There's reservation for people belong to EWS, economically weaker section. So here the issues are whether this 103rd Amendment itself, does it violate the basic structure doctrine? Because they are making reservation based on economic criteria and they're excluding SC, ST, OBC people from the scope of this entire EWS reservation. It's only given to the general category. So the Supreme Court, can we have the next slide, Rintu? Okay. So the Supreme Court formed like that two opinions here. There was split. There's majority and minority opinion. So the majority opinion comprises of 3 judges. Please remember the name of these judges because it might come for the exam, especially majority and minority judges part. So here, Justice Dinesh Maheshwari, Balram Trivedi, and Justice Pardiwala, they held that 103rd Constitutional Amendment does not violate the basic structure doctrine. However, the minority opinion given by Chief Justice UU Lalit and Justice Ravindra Bhatt, they said that it violates basic structure because SC, ST, OBC, they are excluded from this purview of EWS and they're not allowed to participate in open. That entire 10% goes outside competition, right? So it stops competition that way. So, but however, the entire judgment, they upheld the validity of 103rd constitutional. Now, the next case here is Sukhpal Singh Khera versus State of Punjab. This is also another important constitutional judgment happening this year. So, not this year, 2022. So, basically, you guys would know Sukhpal Singh Khera. Sukhpal is a previous cricketer and also comes on TV and everything. So, this person is also a Congress member and he's a MLA. So, Sukhpal Singh Khera, there was a criminal case that was against him. So, the entire issue here is of whether under section 319 of CrPC. Now, the issue here is, can you summon additional accused? Okay, when the trial is going on and before you are passing the state sentence, can the judge summon additional accused during the trial? So, here the Supreme Court held that. Here the Supreme Court held that under section 313 of CrPC, they can be summoned as additional accused, but it should be before the pronouncement of sentence. So basically, during the entire period of trial, before the completion of trial, you should summon the accused, because it doesn't make a sense if you are given a judgment and then you call for an accused. That's completion of the period. But it should be like before the order of sentence, you can summon additional accused. Okay, and the court also issued 12 points as guidelines. Now, here, this case is Jayashree Lakshman Rao Patil versus Chief Minister. This is a constitutional judgment. It's very famous. It relates to Maratha reservation. So, the chronology is such that Maratha reservation 2014, they came with 16% reservation in education and public jobs, and they enacted social SCBC Act in 2014 itself. But however, the High Court struck down, and then they came up with then they constituted Maharashtra State Backward Class Commission 2017, and they proposed 12% and 30% reservation for Marathas in education institution and for public sector positions. Now, in 2018, Maharashtra approved the SCBC Act and offered 16% reservation to Marathas. But this was challenged before the Bombay High Court and subsequently went to the Supreme Court. So the question here is, the main question here was whether the judgment of Indira Sahani itself should be relooked here. And Indira Sahani itself should be relooked. And the second issue is like under Indira Sahani case, there is a ceiling of 15%, right? So when are the circumstances the government can exceed this 50%? So under the Indira Sahani judgment itself, it said that there should be exceptional circumstances to exceed this 15%. So the issue here is, can this 12% and 13% of additional reservation is crossing beyond 50? Does it warrant, or is it because of any exceptional circumstance, and can they prove that? That's the main issue. And another issue is here there is 102nd Amendment. So 102nd Amendment was enacted in 2018. So here what happened is the power to classify certain community as OBC or was given to the president. So the president was the person who was actually categorizing OBC and classes like that, but not the state legislature. Because usually when you say reservation, it's done by the state legislature, but here that power is given to the president. So the issue is because of 102nd Amendment, and also Article 342A was also enacted under that only. So whether that takes away the power of state legislature. So here the Supreme Court bench gave a ratio 3:2. So the majority held that there is no need to revisit the Indira Sahani judgment. They also referred to M.R. Balaji case, and they told that because under Indira Sahani judgment, there must be exceptional circumstances to exceed the limit of 50% ceiling. So here the court held that there was no exceptional circumstance that can be made out from the arguments. So, and other issue here is, however, they all agreed to the point that 102nd Amendment, which also set up the National Commission for Backward Classes, they took away the state legislature's power to classify the backward classes in their state. So because of this, they held that the act was unconstitutional. That was by setting 12%, 13% reservation for Maratha was held to be unconstitutional. But please note that this position has changed now. 105th Amendment was enacted recently, and it restored the power back to the state government. Previously it was with the president. Now it's restored back to the state government under 105th Amendment. So now they get to choose who is the backward. Now another case is State of Andhra Pradesh versus Varala Ramaya. So this case deals with whether the government, suppose there's a current government, whether they can order for a SIT for looking into scams or political frauds committed by the previous government. So here the Supreme Court held that fact-finding committee to probe in the allegations of the previous government, it can be done. It can be done. It's not unconstitutional. It can be done by the current government. Yeah. Now, this is another important judgment that you should keep in mind. Usually, you will see questions from competition law for Clat PG, but you never know. So here, one important thing is this Coal India Limited. So Coal India is a PSU. So in Coal India Limited versus CCI, it was held that Supreme Court held that the Coal India would come under the definition of enterprise under Competition Act 2002. Despite being a government company, despite being a PSU, still it will come under definition of enterprise. So this becomes really, it changes the entire landscape of competition law and market in India. Okay, can we have the next slide? Yeah. In Dr. Balram Singh versus Union of India, this case deals with manual scavenging. So the issue, basically, it was a public interest litigation, and they were seeking to implement the employment of manual scavengers and construction of dry latrines Prohibition Act 1993, and also the 2013 Act. So the Supreme Court, they issued direction to the union government and the state government to completely eradicate the practice of manual scavenging and also rehabilitate the people who were working in this field of manual scavenging, and also give them compensation in tune of rupees 30 lakh rupees in case of death of any family member. In KC Cinema versus State of Jammu Kashmir and others. So this case relates to where you are where you are bringing popcorns or food to the cinema hall. So usually when you go to PVR or anywhere else, you're not allowed to bring your own food or water, even though it costs very high. So the Supreme Court held that the High Court violated its power under Article 226 because it issued direction to the cinema hall owners to not prohibit the cinema goers from bringing foods and drinks from outside into the movie premises. So the Supreme Court held that the High Court violated 226 because they issued directions against the legislative mandate to a private party, and that is not justified. And a balance between Article 19 Clause G and Article 21 should be struck by the courts. This is the final judgment that we'll be discussing in this session. This is a Subhash Desai versus Governor of Maharashtra. This is also called as the Maharashtra entire political crisis, and it's a constitutional judge bench. So here the issue, the facts are such that there are, so basically the Maharashtra, they had a Shiva Sena, Congress Party and International Congress Party. They all formed a government and they had formed an alliance. Now later what happened within the Shiva Sena itself, there was a split, and 56 MLA, they went with another group leader named as Eknath Shinde, and others went with Uddhav Thackeray. So then the issue came with who is the real leader and which is the real political party here, right? So when that issue came, floor test was called for by other members of the Legislative Assembly, and Uddhav Thackeray, he resigned from the post of Chief Minister before facing the floor test. So the Supreme Court held that. Can we please move on, Rintu? Yeah, so first thing is Rintu already discussed Nabam Devia case. That's again another issue relates with powers of the speaker. So here Nabam Devia case is a 5-judge bench. Now this case has been referred to a much larger bench, to a 7-judge bench, to decide whether the speaker can deal with issues, deals with disqualification under 10th schedule of the constitution. So basically, if there is a problem of disqualification on 10th schedule, who is going to adjudicate on this matter? Is it going to the Supreme Court? Is it going to be the Speaker of the Legislative Assembly? So the Supreme Court held that at first instance, the person who has to, the authority who has to adjudicate this matter is not the Supreme Court, and it's actually the Speaker, and should be done within a reasonable period of time. Another important topic here is whether the MLA can participate in the house when when there's already disqualification petition, that's like proceedings happening against him. So this it was held that yes, the MLA has the right to participate in the proceedings, and just because there's a pendency of some disqualification does not stop him from participating in the proceedings in the legislative assembly. Then also the another issue, because there was a split within the party, so there was a split, right? So the issue here is whether it's the legislature party that's a split or it's a political party. So the Supreme Court held that it's the political party and not the legislature party while you decide the split and also the leader of the party. Now, another question is, what's the scope of the Election Commission of India, okay, to determine when there's a split in the party? So it was held that both the Speaker and the Election Commission of India, they both can equally adjudicate on this topic of whether disqualification under 10th schedule of the Constitution, and the ECR will have to investigate this matter based on other tests and other circumstances. Then, yeah, so can we have the next slide? Yes. So the another issue is whether the governor, no, the governor got called for a flow test because there was there was no confidence, right? So it was held that the governor was not right in calling for a flow test, because just because there was there was speculations about a split in the party and all does not prove that he lost the confidence of the house and he shouldn't have called for the floor test. But however, unfortunately, what happened is Uddhav Thackeray resigned before the floor test itself. So that's why you cannot just go back to a situation and make him the chief minister. He resigned his post, and Eknath Shinde ended up becoming chief minister, and because he has the next majority, and he continued to be the chief minister. So that, yes. So we received, I think, some doubts later. Do you have any other questions or doubts regarding the case laws that we discussed now?
You can give your questions in the chat box, otherwise it'll be a little difficult. So I think Aloy has raised his hand.
Okay. Vijeta, we had already discussed regarding this. So the main syllabus for Clat PG exam will be, of course, constitutional law, because I showed you in the graph itself, like 30 questions comes from constitutional law. So first important topic, constitutional law. Then you can also read through, focus on family law, your criminal law, corporate law to an extent, Contracts Act, international law, and also environment law. And someone actually, I think, raised a question earlier regarding labor laws. It's not usually, we don't see much question coming from labor laws. It's limited to this topic. We don't see labor law questions. And someone else had raised another question. They asked whether, what are the important event under international law which might come for Clat PG exam, and we think, I think that the ongoing conflict Palestine and Israel can be one of the topics coming under international law passage, because it's a current affairs matter. Because in 2022 they asked, there was a passage on Ukraine and Russia conflict, so there might be another passage on this topic.
Unfortunately, we won't be able to send it to you in PDF form, because so what we have done is we are only giving PDF form questions and notes in PDF form only for people who are actually purchasing from our store. This is actually a one-time introduction that we just wanted everybody to know that, this is what we are doing. But this we will be able to give it to you only in PPT form. And yes, so we have, I have actually sent you the link that is directly from the Clat consortium itself. You can go through the syllabus, and that is on extensively. So you have 120 questions, 1 mark each, and you have 2 hours, 0.25. That is quarter, 1/4 of a mark would be your negative marking. So therefore, it's very important that you manage your time, and there is no time for you to go think there and sort your answers. You have to be very quick in everything. Your thinking and your marking, everything has to be very quick. That's precisely why you need to prepare extensively and exhaustively for the exam. And that's precisely why, mediums and people like us and other mediums like us are present in the market to help you out. Can you please state how a judgment should be read and what all paragraphs are needed to be stressed more? See, there is no shortcut to this. So the only thing that I can, or that we can tell you is there is something known as speed reading, right? So the idea is to understand the issues in the judgment first before you read, because only then you can understand what the judgment is on. So just a moment. Yes. So basically, the thing is, in most judgments, the issues will be framed by the court itself, and more often than not, the issues are answered as to, first issue, this is the answer, second issue, this is the answer. Sometimes it's not done. So what you need to understand is when you read the issues, you will see certain keywords. For example, if you're talking about a case on privacy, and fundamental right to privacy will definitely come in, your articles will come in. So that becomes your keyword. So it's very important for you to understand where this keyword comes in. You have the option of control F, understand. So it's called speed reading. You quickly analyze the judgment, and then you figure out, okay, this is what the judgment is talking about. But apart from that, there is no shortcut. You will have to, this is also speed reading only. It's not selective reading. You need to understand that. You will have to go through it. Now, if it is difficult for you to analyze what is important, like I said again, that's exactly what we do. We summarize the judgments for you in such a way that it's easy for you to understand. We have, like you just saw, we have tables, we have diagrams, we have everything in a very colorful and interesting manner so that you are able to study effectively. And so I think I've answered Malik's question. Ma'am, some people said it includes other subjects which will be there in Clat UG. Is it right? I'm not sure exactly what the question is on, but if Sukanya, would you like to take it?
Yeah. So in Clat UG exam, you have logical reasoning, English, and everything. So this kind of pattern is in NLUD entrance exam. They ask English, logical reasoning, as well as general knowledge and everything for a Clat, NLUD PG exams. But this is not there in Clat PG exam. This is strictly only deals with legal questions and nothing relates with nothing English, general knowledge, nothing like that. It's not same as UG.
However, you need to understand that the questions would be asked in comprehension form. So because it's asked in comprehension form, the exam sort of requires you to be up on your vocabulary. You need to be good with regard to comprehension. You need to be in a position to understand what the particular comprehension says in just one go, or like what right after you read it once, you need to understand. And
also Shreya. Yes, so I saw your comment. So basically, you're asking whether only these 40 judgments will suffice. Unfortunately, not, because they have a pattern where you have to stress on judgments from 2016 itself, because the pattern has changed. So you have to look into landmark judgments starting from at least from the year 2016. When that's not guaranteed, they can even go back beyond, but not that old cases also, but still. So under smart revision plan, which you just asked, we are providing 100 Supreme Court judgments from the years 2016 to 2023. Please note that these are like handpicked. So we have chosen which are like most important, like there may be like constitutional bench cases or cases where things have changed a lot. So we have focused on these judgments and have prepared 100 Supreme Court judgment summaries. So if you use that smart revision plan also, that will help you with the exam. And in addition to this 40 judgment that we just discussed here.
Please note that in this smart revision plan, whichever plan you're taking, you will anyway be getting these this PPT as well. You will also be getting Shreya Shetty, does it include legal provisions as well? See, so we have structured it in such a way that the Clat consortium asks you questions on Supreme Court judgments. It does not give you like a paragraph from, just like that. These are Supreme Court judgments. 85% of the paper, like about 70 to 80% of the paper is Supreme Court judgments. You do have sometimes on jurisprudence or international law when it's not on a Supreme Court judgment. But when you are talking about something like, Do you have general provisions? We don't provide general provisions because that is not the pattern. However, we have general provisions when it comes to constitution, because constitution carries a lot of weightage and it's important to understand static questions. So tax laws really haven't come except for 1 year, and that too not exactly tax laws. It just touched upon about 3 to 4 questions came, but apart from that, tax laws have not been asked in the previous years. And you need to understand after 2019 or 2020, the pattern has been changed completely. So Abhirami Mohan. Okay. So the thing is, obviously when you're attempting a examination, it's always best if you read the question, because sometimes they could give you a paragraph and they could ask you, so sometimes which of these cases don't deal with something. So if you don't read the don't, that's very problematic. So something that you really need to have at the same time is patience and speed. You will have to work your way through it. There is no shortcut. And if you're asking about the comprehension as such, we would suggest you to read the comprehension at least once and try to understand what is the heart of the comprehension. So that itself will give you a lot of insight for the next 10 questions. So that will really help you understand.
Abhirami, to add on, also there might be some static questions that you might already know the answer of. So, if you like when you're, I understood your question. Basically, should you read the questions first before attempting the passage? And it's normal for all of us to first just go through the questions and see whether we know something and then read the passage. So, I think you can save some time if you just quickly go through the question. Suppose it's a very direct question, you already know the answer, very static question, like how we saw the CSR, what's the percent of contribution they should make? Just 2%. So this is a very static thing. You won't, even if it's in the passage or not, you know this. It's a static question. So for questions like that, that's helpful. But however, for questions where you need to apply, depending on the passage, your answer will change. So you should not just go ahead and read the question. Depends on passage to passage.
And also one more thing is, sometimes what happens is, if there are 10 questions or even 6 questions, you see that some of the answers are within the passage itself. So for that, you need to, for that, it's imperative that you read the passage, Like Sukanya said, some of the questions are static, but the percentage of those static questions are getting lower by the year, so you need to understand that. You do have your static questions, but out of 120, the number is quite, low. It would be like less than 20 questions for that matter. And for a good number of questions, especially when it comes to subjects like jurisprudence, sometimes even consti cases, and definitely on international law, you have your questions within the passage itself, like a good 2 to 3 questions out of 10. And that would, and when you talk about Clat, even 0.25 makes a huge difference. I mean, I don't have to tell that, because I'm sure all of you would know that 0.25 also would make a tremendous difference in terms of your rank. So that is very important. So attempting leaving one question or getting it right might make all the difference.
Okay, so Aloy, you said you're going to prepare for 1 full year for CLAT exam. So when you're preparing for next year, as we just mentioned before, you need to be thorough. All the previous year, that year, all these judgments should be prepared from 2016 at least itself. So this will include 2021, 2022, 2023. And if you are planning to write in 2025 exam, you need to again go through 2024 judgments, which are very important for your preparation. And when you're preparing for 1 year period, you should have a good understanding of your basics in constitutional law, and also focus in criminal law and evidence act. So you need to have a thorough understanding of constitutional law. Majorly, you should have a good understanding of constitutional law. So this is how you should be preparing for 1 year period, by constantly keeping tab on all the recent judgments that's coming in 2024. And Shreya, just saw your question. Considering there are 8 days for the exam, we have already provided like today we discussed 40 judgments from 2023, and also we'll be having, if you take smart revision plan, we have additional 100 judgments, which will cover at least your 2016 to 2023, and we are not. Will not be like extensively long, like reading a judgment. A judgment will be like 160 pages, 80 pages. It's too long. So we have summarized them small, 2-3 pages, or some even 1 to 2 pages, depending on the content of the judgment itself. So you can go through the plan and read it, you'll be able to finish off this 100 judgments, I think. And if you
Just
feel you want
want
to, yeah,
sorry.
please continue.
So sorry to interrupt. So Kanya, just to add one thing, please don't think that just because it is within 2 to 3 pages or 2 to 4 pages, we have compromised on the quality. You can just go. I mean, even right now, we hope that the session was very helpful for all of you. You can see that we have really picked out what is we have colored out what is the most important aspect with regard to one judgment. What are the issues and what the court has said, and if there's a dissent in that we have mentioned. We have also tried to include diagrams and tables maximum wherever possible. So we are not compromising on the quality. We are just trying to make it more effective for our students. That's all.
Yeah, and there's also a question from Jatin. He is asking whether the same-sex marriage as international law marriage would come for the exam. The thing is, marriage is a very territorial thing. Like every country will have its own marriage laws. You cannot make it an international issue. But still, there will be an issue on gender, gender equality, and also the rights of the transgender community. These are all common to all the countries, but not like marriage as such. But all these topics will be common. Also, topics of abortion, which is again another important topic now. Women's right of body autonomy. So these are all again important topics.
And also, Jatin, if you're talking with regard to the same-sex marriage that happened in India, see, that may not have an international relevance. It only has a national relevance. And that too, we have what you say, at this point, we haven't given any recognition, or the Supreme Court hasn't given any recognition. One more thing that is important for your international law would be Roe versus Wade, because it was, the American judgment that came out. It is very important in terms of, international law. Good to go through that judgment. And again, like Sukanya mentioned, your Israel-Palestine war, that is also an important aspect. Just go through what is happening generally. So for 2 years, we had the Russia-Ukraine conflict that came up for the exam for 2 years. And that took consecutive years, because that was the most thing in international law. So that is the thing. Is there any other questions? Are we missing out anybody? We're not sure, because a couple of questions came, simultaneously. So we hope we've covered all questions. And Aloy, as of now, we don't have a comprehensive Clat PG course which you can avail for 1 year. We do have the current courses, and the thing is, we don't like to stay static, because the syllabus keeps changing. So what you can do is you can purchase one of our options right now and go through it, because we will be adding on to this. So this is what we'll be doing, because there's no point staying static in an exam that is very, what's very dynamic. So that's the only thing. Is there anything else? Thank you so much, Tanya. Thank you so much, Mansi. I mean, it is your encouragement that helps us go forward. Thank you, Shreya.
Good evening, ma'am. So I believe there are no further questions. I'd just like to thank you both on behalf of Team Legal Vidya for conducting this wonderful session. It definitely has been great. As you can see from all the comments, everyone had a good time in the session and they learned something. So thank you so much, ma'am, and thank you so much to the team of SR Clat Notes. It was a great session, and we look forward to working with you again in the near future. Thank you so much, ma'am.
Thank you, Team Wikipedia. I have also pasted the link to a store. So if you need any other information on this, please click on the link and also contact us.